This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
So welcome to BRD. And by the way, the reason I'm smiling is not just because I just saw Gary. It's not just because I heard Awesome Dawson. I just saw maybe the cutest little 2-year-old I've ever seen.
Well, thank you very much. Gary Jr. there has become quite fond of Uncle Mark. So anytime we're doing a Zoom from home, he wants to come say hi.
And I'm going to send him a picture of the world's largest gingerbread house that is here at the hotel. I've never seen anything quite like it. And kids at first don't even know what to do when I'm watching them as they take a look at this thing. It's unbelievable.
Just mind bending. So you're still joining us from Salt Lake City.
Yes.
I can hardly figure where to start.
Well,
Britney's
I know
free.
it's just Britney's free, which remember when that was a story?
I mean, that was the biggest story. And right. By the way, my wife is sending me photos from outside the courtroom. And she's like, it's a Friday. Where are these people? Don't they have jobs?
Yeah, I think any way you cut it, you've got to give credit to Matthew Rosengart, who turned around the Titanic awfully quick. So
I mean, what was it? 6 months between him coming in and all of a sudden we're completely where she wanted to be, apparently?
Yeah, and just say a prayer that she can hold on and gets the help that she wants and deserves, and they untangle some of the other kind of collateral matters. And the talk of here where I am has been the Rittenhouse trial. I'm surprised that has captured the imagination. I've had many a conversation in the last 2 days about that. The judge has gotten rave reviews here where I am, but there is a contingent of people who have been very hard on him. A
large contingent. I mean, there is a certainly a narrative that he is unhinged. To a certain extent.
And I'm not quite sure where they get that from. Because he's using his command voice, because he's holding the prosecution accountable, which is, by the way, they will do that for the defense. If any other defense lawyer walks over the line on a motion in limine hearing, you're going to get upbraided the same way. I mean, this judge strikes me as, although his reputation prior to this trial was very pro-prosecution. It's funny, be careful what you wish for. I mean, I mentioned the other day on the other show that they actually had to bring in another judge to handle all the cases where they could use what we call peremptory challenges against this judge. And it was almost exclusively apparently used by the defense. So this was not somebody who was viewed as a light touch or a soft touch, so to speak. But some of these errors by the prosecution, I mean, putting on a witness, I can't imagine, maybe I'm wrong, but I can't imagine they didn't know that witness was going to say that pointed the gun first. It's shocking to me if you put a witness up and you don't know that question is going to be asked, because that's the basic, you're talking about a self-defense. By the way, you've heard the opening statement, so talk to your witnesses.
It boggles the mind because we've all seen these videos where a skilled, defense attorney will ask 5 or 6 questions that are all a jujitsu move that ends in the 7th question where the guy is stuck and he has to screw himself over because he's been skillfully, mastered. That question wasn't part of a jujitsu move. It was the most basic question. It was, of course, this question will be asked. How is that not asked in some conference before he's ever put on a witness list? But
and how do they not preempt that? I mean, remember, part of what you want to do in a courtroom, you've got to lay bare. You have to be your authentic self, because jurors will smell you out in a heartbeat if you're not. And if that's the case, preempt it. Be upfront. Don't try and play hide the ball. And then you compound that with the Griffin error, where you ask about post-arrest silence, and most judges' heads are going to explode. They're not going to put up with that nonsense. He's right. It's been the law for 50, maybe 55 years. I was just a pup when that case was decided, but that just is mind-boggling to me.
Yeah,
I do think you're going to see a conviction, though, on the gun counts, and that'll be or a split verdict, as they say.
Yeah, I've seen those on Twitter who disagree with you, but I always wonder if those people are consuming this case entirely on Twitter, because I can understand, I suppose, how someone who is consuming this case that way thinks that this judge is crotchety and past his prime and whatever. But I mean, ultimately, I've been watching a lot of this trial just to keep up with it, because I know we're going to be watching it, talking about it here, and they've been chipping at him. And yeah, then you get the 2-minute Twitter clip where he's yelling at the guy for straight ignoring pretrial motions. I mean, it wasn't, you're being kind. You said earlier that, the prosecutor's made several mistakes, and I'm sure he has made a few, but he's also blatantly just disregarded the judge's instruction a few times. And that's bound to get an accomplished, 40-year person sitting on the bench frustrated.
I have no disagreement with that whatsoever. I think there is a compelling argument that they were goading, and that's the term we've talked about, goading the defense into asking for a mistrial. And if that's the case, that's with prejudice. That means you can't retry him. But most judges, I think, also the last thing they want to do is declare a mistrial on that basis, because it would have to be prosecutorial misconduct. They would rather first let the jury do something. And if the jury does something, and even if the jury convicts on the gun counts and acquits on the others, the judge could grant a motion for new trial on the gun counts, or he could dismiss. I mean, he's got that authority. So it's really, this week is really going to be something.
I guess my question for you would be, how is the gun charge even remotely in question? I mean, it's the law to me says that you are not allowed to possess a firearm if you are under the age of 18. That doesn't seem to be in dispute to me.
And the jurors will get instructions that are pretty cut and dry, but that will lead us to our next story, which is Steve Bannon, the former chief strategist for Donald Trump, was indicted yesterday for criminal contempt of Congress, 2 counts, I believe, for not showing up and for not testifying,
producing documents as well.
Yeah, and so I've actually tried a criminal contempt case, not once but twice, and they seem pretty cut and dry. However, what you have to remember is that there are certain privileges that you can assert that will tend to give you either a defense or the ability to get a jury instruction. And if the one case I'm thinking of, the obstruction, she was acquitted on that, and then 7-5 for not guilty on the criminal contempt counts. And that broke down almost exclusively on political lines. 7 Democrats voted not guilty, 5 Republicans voted guilty. And so there's an argument to be used there. But one of the coming attractions of this is if the Republicans take over the House, in the GOP takes the House in 2022, which right now looks probable. Imagine they start bringing administration officials down to Congress when they're in control of Congress and start issuing or do referrals to the Merrick Garland Justice Department for criminal contempt on various issues when they're alleging executive privilege or they're alleging other kinds of privileges or immunities. I think you're going to have, and mind you, for those who say that's never been done before, a case that Adam was kind of fixated on. Remember, I believe that Lerner, who was the
Lois Lerner,
right, IRS commissioner, and they wanted Lois Lerner held in contempt, a GOP-controlled House, and Eric Holder, who was then the Attorney General, I believe, did not do it.
Correct.
So it's I don't see the political infighting played out in the criminal justice system ending anytime soon. In fact, I think it's going to be, you may even have, it'd be interesting to see if Steve Bannon puts his case over long enough so that the GOP takes over the House. Well, for all we know, they could withdraw the subpoena. I mean, they could say it was improvidently issued or come up with something else. And then what's going to happen to a court case under a grand jury indictment?
It's going to provide for quite a bit for us to talk about here on Beyond a Reasonable Doubt and on the Best Hour in the Universe.
Absolutely. Absolutely. So this week, I imagine we'll have some updates, right?
We will. There's 500 state guardsmen out in Wisconsin waiting for a resolution there. We've got Bannon developments. We've got nothing but news coming for Reasonable Doubt. So we will see you guys. And
Ghislaine Maxwell starts, I believe, on Monday.
I think it does.
And she's speaking out about her conditions in jail. There's a Daily Mail article I read where she talks about the fact that she doesn't take showers every day because the guards are treating her creepy, and that there's usually when she used the loo that there was a rat that would join her until the rat attacked one of the guards, and then they finally put a cover over the sewer hole. So, I mean, it's quite a stunning situation. She's got an uphill battle, but she's got very able lawyers, and the prosecutors are very able. So it's going to be quite a battle.
It's going to be interesting to watch, and we will be watching closely. So, Mark, thank you so much for taking some time on a Saturday. I will look forward to connecting with you again this Tuesday.
You got it. Thanks, Gary.
All right. Bye-bye, Mark.
Bye-bye.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.